All right, welcome back. We are now joined by Melusi Qulu, who's a legal analyst, to speak to us about Advocate Shamila Batohi walking out of that Nkabinde inquiry. Thank you so much for your time, Qulu, for joining us this evening. So maybe let's just start off with getting your reflections with regards to Advocate Batohi and her conduct this afternoon at the Nkabinde inquiry.
Good evening to Katlego and to the viewers at home. My view is, look, she said she needs to get time to get legal counsel to advise her on her options. I think for me, it shows that when she was being cross-examined, a lot of things were exposed about how she did her work, especially obstruction to justice, how she was cross-examined, especially today. And I think her lack of preparedness also is an issue for me. But I think today, more than anything, Katlego, it showed why in the beginning, before she was cross-examined, she did try to show that she's not comfortable with cross-examination. And the chairperson stated that she must continue to be cross-examined. And today we are saying that she is really not comfortable in doing so because she what her options would be, but obviously the advocate for Advocate Chauke is not happy, especially Advocate Nkabinde.
Speaking about Advocate Nkabinde, I mean, in the clip that we just witnessed now, there's the last statement that he made, and he said the last time someone walked out of an inquiry, there were serious legal consequences. Would you compare abstaining from answering questions by Advocate Shamila Batohi to Jacob Zuma's walking out of the Zondo Commission?
Well, the similarity between the two is the fact that they are refusing or they refuse to answer. That's the first thing that I picked up. Maybe one would say there's a difference because with the former president, Usholozi, he actually wanted a recusal of the person who was heading the commission, which was Justice Zondo. And then after that, he walked out and they said they will not proceed whilst he's still there. So that was what happened. And remember, they then went to the Constitutional Court to get a court order to compel the former president to give evidence. In this case, where it's slightly different, maybe she's saying she wants to get legal advice before she continues, but the bottom line is she's refusing to answer. So if that is the point or that is the position, I wonder if there is anyone who will have maybe the enthusiasm to, take the matter to a higher court and say, since it's not clear when she's coming back, she must come back and be compelled to give testimony. That is what I'm curious about. But obviously, I believe that Advocate Nkabinde stated that if she has walked away and she's not coming back, it's not clear when she's coming back, she's waived her right to be part of the proceedings. And I think that is a strategy to make sure that the key witness, and I say this in inverted commas, the key witness in these proceedings, what she has testified about, which was clearly not really good evidence for a complainant, again in inverted commas. Maybe they just want to do away with it and then be able to prove that everything that the NPA or the witnesses are trying to prove against Advocate Chauke should not be taken seriously.
And I want us a little later to go back to that with regards to waiving her right and then the weight of her statement in all of this. But if we still stay on the issue of comparing the two refusals, within the legal system, how do you then differentiate between a lawful refusal as well as a contemptuous conduct when it comes to the two different situations?
Well, whether it's lawful or any other refusal, what is important, Katlego, is that when someone says they're refusing to continue to testify, if the people who are involved in those proceedings are interested in making sure that the person comes back and testifies, whether it's a commission of inquiries or in court, they obviously need to just get a court order that will compel that person to come, so that if they don't come after they've successfully obtained a court order, they will then apply for contempt of court. Although it was debatable in the Zuma case where there was a constitutional court order, and then when they got it, they simply asked that he's arrested, which there was a debate about whether they should have at least opened a criminal case before he was arrested, because there was no trial. But there's something that we've dealt with, and there's no way going back to it. But a precedent was set. So a precedent was set that if there's a court order, whether there's a trial or not, and after the court order you refuse to testify, still you will be arrested without a trial. So I'm waiting to see whether the same will be done in this case as well.
Yeah, it would really be interesting to see if that precedence would be seen through even in this particular situation. So going back to the issue of her waiving her right, Advocate Nkabinde also hinted to possibly them in the near future, or in the meantime, having her statement struck off the roll. What would then this mean for the commission itself, but most importantly for Advocate Chauke?
Well, I think he also mentioned that not that they want to be difficult, but that's the rights that they want to use.
Yes.
Well, I believe for the commission, it will simply mean that whatever has been testified will not be taken into cognizance or seriously. And for Advocate Chauke, it means now he needs to focus on the next witnesses that will come, which will be obviously Advocate Masana and the rest that will come, which I believe it will just make things much easier. But even if the testimony is not struck off, if we logically look at it, do we really believe that in terms of the terms of reference and in terms of showing that, Advocate Chauke is not fit to hold office, has she done enough? So whether it's struck off the roll or not, I'm of the view, Katlego, that I don't think she's done enough. And by her walking away, when you see a witness walking away from further being cross-examined, that shows you that even the witness does not trust what she's coming to do in that particular platform, whether it's a court or it's a commission of inquiry.
So in such instances, then, Melusi, how would legal institutions just balance that right to silence with the need for accountability and transparency?
I believe in the Zuma case, our former president, in the Constitutional Court, it was stated that if you refuse to answer for some reason, you must have a legal reason why you cannot answer at that particular point in time. So you can't just say you don't want to answer. You are compelled to come and give testimony. And if the chairperson believes that your reasoning or your legal reasoning is enough, obviously they will allow you not to answer. So the law is simple. You cannot just say you have, for example, we are not in a trial here. In a trial, you obviously, according to Section 35 of the Constitution, you obviously say you have a right to remain silent. But here we're not in a criminal trial, we're in a commission of inquiry, or rather we're in inquiry to look at the fitness of Advocate Chauke to hold office. So you can't say you have a right to remain silent. It does not apply here. You can only raise a legal reason which is sufficient to say you can't answer. But if it's not sufficient, you'll be compelled to answer.
Then, so in that principle and in that thinking, do you think that such refusals have an impact in the pursuit of justice and the truth in such commissions of inquiry?
I believe they do, but as long as your reasoning to not testify is proper in a manner of speaking, then obviously you will be allowed not to give evidence. But it affects the pursuit to the truth and justice. And we must remember, Katlego, that ironically, the vision of NPA is to ensure that there's integrity and to uphold justice in our criminal justice system. So we are waiting for that to be seen through the officers of NPA that are giving testimony in any platform, including this inquiry.
We know that Advocate Batohi had initially requested for the inquiry to begin in February, and this would be after her retirement at the end of January. Do you think this might still be in line with her only wanting to return thereafter that retirement?
Maybe there's a strategy to that, but I think she just needs more time to properly look at how she wants to testify. And I will say that based on 3 reasons. The first reason, she did not want to be cross-examined. So it was clear that she was not ready to give answers properly. The second reason why I'm saying she needs more time is because when she was being cross-examined, she stated that the advocate Novaitobi SC must not be fast because she was to write down, which is unusual when you are cross-examining a witness, because a witness who knows what she's talking about or he's talking about will not need time to write down. But I suppose she's a perfectionist. And the third reason why I'm saying she needs more time is because when she is bank cross-examined or she was bank cross-examined, she would say she needs to think about those things that she spent cross-examined on. And Advocate Noaitobi will say, but you can't be thinking when you've been testifying for the last couple of days. And especially, I will add, she's the one that lodged a complaint 2 years ago, so she should know what she's talking about. And maybe the fourth reason that I'll add is the fact that she walked away from, or allegedly walked away, whichever way you look at it, or abandoned, continuing. And that shows for me that she cannot continue because she just needs time to prepare. But I wonder what else she can bring to the table, because what is there, the evidence, what we are following is the evidence, nothing else, and it cannot change. The emails are there, the documents are there, and now it looks as if, Katlego, if I may add, and I think this is a school of thought for many people that have been observing this. It looks as if the inquiry is no longer on the fitness of Advocate Chauke, but now the inquiry is on her fitness to be an NDPP. And I think this is very interesting to observe.
Yeah, and just on that last note, do you think this has any impact on the legacy that she would then leave, not only from the testimony that she gave at the ad hoc committee, but now in what we're seeing playing out at the Nkabinde inquiry?
I think we still need to see her on the commission, on the Madlanga commission as well. Yes, she did testify in the ad hoc committee at the Parliament, but to us then to holistically look at her legacy, I'm still interested in seeing her testifying at the Madlanga Commission, especially on the PKTT issues. So I think her leadership will be based on the fact that did she uphold the vision of NPA when she was leading? That is the most crucial point. And was there any independence in how she dealt with the matters? And did she pay attention to detail? For example, if she says the emails that were sent to her, but she assumed that a deputy would take care of those issues, it shows that she did not take responsibility for her leadership. But for now, I don't want to put the cart before the horse, as I always say. Let's allow the whole process to unfold. It's just that I'm picking on the things that we've seen. Maybe there will be some reasoning when she comes back and she gets enough time to get legal advice from a legal team on how to proceed and so forth. But obviously there is frustrations, and from the commissioners of this inquiry, including the chairperson, there is a view that she has not been respectful for a person of her caliber to do as she did today, not just today, but before, how she was not that helpful. I think it raises concern, and the next NDPP has a lot of work to do.